Well, good morning, everybody, and a very warm welcome to this panel, both in person and online, on quantifying damages in global class actions. My name is Liam Colley, and I'm very privileged to be chairing such an esteemed panel again. And I'm sure, like me, you're all very happy that at least some of us are able to do this in person at last. Let me introduce the panel. With me live, we have Greg Harman. Greg is a very experienced testifying expert at BRG. His experience embraces antitrust regulation and valuation, and he's involved in several class actions in the UK at the moment. Joining us from Amsterdam, we have Leonard Böhmer, who is not an economist, not that we would hold that against him. He's an instructing solicitor at CMS, and it has been and is involved on many class actions, working on both sides of the V in Europe. And we also have Greg Leonard, a highly experienced practitioner from Cornerstone Research. Lots of his experience on very complicated financial services matters, including class actions. And he was going to be here this morning, but apparently his train line let him down. And so if there are any funders out there wanting to pick up another train case, perhaps they can talk to Greg about the reliability of that line. And then there's myself. I'm an antitrust economist, testifying expert at AlixPartners, also involved in some of these cases. So regular attendees to this session will have noticed, as I indicated, that this year we're not just all economists, and we have the luxury of also getting insights from an instructing solicitor. I think it was George Bernard Shaw who rather unkindly said that if you lay all your economists end to end, you may fail to reach a conclusion. So Leonard Böhmer, your role on this panel, I think, is somewhat clear. You'll also have noticed that we have two Gregs and two Leonards. So I'll be using full names to try and at least cut down some of the confusion. Let me start with some observations before framing the discussion that the panel is going to cover. So the first thing to say is, well, what a difference a year makes. There we were last year, all online, in the thick of lockdown, tapping our fingers, waiting for the Supreme Court in Merricks. And now here we are with the floodgates well and truly open, 12 cases in the pipe, three decisions already, Lloyd Google, hot off the press as well. And what a rich picture it's turning out to be. Just looking through the sort of quantum lens, we have a mix of standalone and follow-on. We have 102 and cartel. We have carriage disputes where the quantum methodology is featuring heavily. And all this in the context of large, ongoing, parallel opt-out proceedings and some truly gargantuan claims as well. What more could we ask for? And I think the second observation is that the CPO regime is clearly turning out to be rather claimant-friendly, a low bar for commonality and suitability of an aggregate award. This in the context of what is frankly a rather ambitious claim in Merricks, and I'm sure I'm not the only one who detected a degree of anxious deliberation from the CAT regarding the prospect of windfalls for the funders in boundary fares. Also, I think clearly a wide scope being given for Article 102. The CAT emphasising the list of potential abuses is not exhaustive under 102, and that is not going to be second-guessed at summary judgment. And I think we are seeing, or some would say, a bit of shoehorning of what you might see as consumer protection issues actually into the antitrust opt-out regime. And then data, wide latitude being given to claimants on data to fill in the gaps with sensible extrapolation, survey evidence, you don't need to specify that at certification. Even natural experiments have been talked about, and the court emphasising its willingness to rely on a heavy pragmatism, informed guesswork, and a broad axe. It's not all one-way traffic. Bit of pushback on claiming for deceased persons and compound interest, and obviously the result in Lloyd Google wasn't what the claimant wanted. But even there, many have observed that the Supreme Court's messaging around commonality does seem to have widened the scope for group actions under 19.6. So all in all, I think funders and claimant firms will be looking forward to Christmas. We're feeling pretty happy about life. One final observation before we dive in is I think there's a remarkable focus emerging on excessive and unfair pricing in these cases, clearly at the heart of BT, also featuring heavily in other cases like Apple, Google, and Qualcomm. And as the CAT emphasised in BT, these cases traditionally have been rare. The authorities loathe to cast themselves as price regulators, but there they are, and they're featuring quite heavily. And I wonder whether we are, to a certain extent, entering some uncharted waters here, because the UK is now rather distinctive at having a vibrant opt-out antitrust regime and a clear prohibition, unlike the US, and I believe Canada too, against excessive and unfair pricing. And as the CAT reminded us in BT, the standard here might be pretty low. The Court of Appeal in Flynn indicating that prices in a market where competition has not been weakened by the presence of a dominant company may be a relevant indicator, not the only one, but a relevant one. Now, when you consider that actually dominant companies should be pricing above that level, that is, after all, the incentive and reward for trying to become dominant, a process we would typically refer to as competing, then I wonder whether we're going to see a slew of these cases from all sorts of sectors where you have dominant companies. I don't want to sound too Cassandra-like, but I do suggest that we watch this space. Right, so turning to the areas where we're going to be focusing, I'm going to be asking the panel to focus on today. There are three main areas. First of all, what are the general implications for the emerging cases for the expert evidence, in particular for experts that can be geared up to deploy really quite complex analysis, and we're seeing that on FX and trucks. How do they deal with the court's emphasis on a pragmatic approach, informed guesswork, and a broad axe? Secondly, on global cases where you have wide variation in terms of the commonality standard, the ability and willingness of the courts to deal with complex analysis, and the timing and extent of disclosure, what are the implications of all of that for designing and framing your expert evidence plan? And then finally, what are the sort of general takeaways and potential pitfalls that instructing parties need to think about when designing the expert evidence plan and making sure in particular it's robust enough for the various vagaries of winning and losing on certain legal points, for example, single and continuous infringement, to name but one. So those are the sort of three areas we're generally going to cover. I think each panelist is probably going to focus on different elements of that. We're going to start off with Greg Harman, and then we'll hear secondly Leonard Böhmer from you, if that's okay, and then Greg Leonard finally. We'll come back, we'll iterate, we'll take questions both from the physical floor and the virtual floor as well. Okay, so that's enough from me. Over to you, Greg.
Thanks, Liam. I'd like to touch on maybe three areas. One is the issue of compound interest and commonality. And then I'd like to talk a little bit about surveys, and then maybe pick up a few points on natural experiments. Obviously, in the Merrick's case, we have a finding with respect to compound interest. So there was a claim relating to overcharge of up to 7.2 billion, and it was put forward as an additional loss relating to compound interest of something like 8.8 billion. Now, it's pretty rare that the interest element of a claim is bigger than the main part of the claim. I mean, that can happen when there is a long time period. But given the size of that, I think one does really have to think very carefully about commonality issues and how you actually come up with the right rate for interest. Now, in that case, two things were put forward. One was we could calculate some kind of average cost to consumers, either by having a mix of savings and debt, or we could have a subsegment, subclass of just looking at people with debt. And we could also do a survey, and we could ask the question, if you were given £10, would you use that to reduce your level of debt, or would you use that to increase your savings? Now, the £10 is effectively the overcharge expressed on a per consumer per annum basis. So it's a relatively low amount of money. And the CAT, rightly, I think, suggested that the survey was asking the wrong question because they didn't suddenly have £10 at a point in time, but that amount accrued through time. And if people were making purchases on a weekly basis, then it's about something like 20p per week. Or if they were making payments on a daily basis, it's about 2p per day. And so the CAT asks, is there another alternative? That alternative being, at the end of the week, when you found you had 20p more, you just spent it on something. And the survey would fail to pick that up. They also pointed out that irrespective, that survey would just give you an average across the population. And the question then becomes, does everybody have the same set of characteristics that applying an average cost of debt would represent what their actual loss was? Now, in MasterCard, Sainsbury's, and in Sempra Metals, the standard around compound interest was, we can't deal with the theoretical or the hypothetical. We have to understand actually what people lost. And I think that when it comes to consumer claims, interest is particularly difficult because everybody has a different portfolio of types of debt, types of saving. I mean, if we did a poll here, there was probably no commonality as to what the mix was. So if you think about it, you think about the level of debt that people might have, obviously mortgages would take up a big proportion of that. There's some 11 million people in the UK that have unpaid mortgages. Most of those are on repayment mortgages that have fixed terms, fixed payments. Interest may change, but it's a fixed payment. And they may have penalties for early repayment. So unless you had an offset mortgage where all of your finances were combined, there's no direct route from having an extra 20p a week to suddenly say, I'm going to pay down my mortgage. There may be, but it's not necessarily direct, and everybody may have a different view on that. When it comes to other forms of debt, you have credit cards. Then there are two types of people. There are transactors who pay off every month and pay no interest, and there's revolvers who obviously pay interest when they don't pay all of their accounts. So that's another difference. Some people will have savings, but the statistics suggest something like 40% of people have virtually no savings. And in all of that, everybody's going to have different rates because they will have taken out debt at different times. They will have different credit ratings, and obviously their mix of savings and debt also changes over time. So it's a complex area, and I suspect, difficult to come up with one rate that fairly represents everybody. Now, that's not to say that you couldn't segment the market more, maybe by credit rating, maybe by types of debt, people that have mortgages, and so on and so forth. But I do think that one has to consider if there is benefit from performing more work. So in this case, there was a calculation for simple interest of something like 6.6 billion, and compound interest was 8.8 billion. The difference between those two calculations is about £3 per person per year. And I think there's a credible question as to whether that is material and warrants potentially quite an extensive assessment of interest on that basis. Now, that's a legal question. I'm sure that the segmentation can be done, but maybe it's more relevant for bigger claims in the first instance. So that's a bit on interest. On surveys, I think surveys are a great tool for trying to obtain information. I mean, there's many bad surveys out there, and that's why they they get questioned. And often people use surveys that were performed for some other purpose to support, their own case. So it's all about survey design at the end of the day. And there are many courts and areas where survey evidence is used. So the CMA thinks that survey evidence is very good for merger analysis. Surveys are widely used in trademark cases and in royalty cases. And actually in the trademark world, there is a set of guidelines called the Whitford Guidelines, which effectively says that a set of, a survey has to have an identifiable population. How are you going to segment that? What is the sample size that's going to allow you to be statistically significant? A clear understanding of the methodology, and don't ask open questions, because obviously that can lead to biased results. From an economic perspective, that's all reasonable at the end of the day. And the good thing about surveys is that they're a very efficient way of obtaining information from a population, a large population, because the sample size does not scale with the size of the population. So, for example, if you wanted to get a statistically significant representation of height across 1,000 people at a 95% confidence limit, you would need something like a sample size of 370. I've not disclosed all of my assumptions there. Take it as that's a reasonable thing. But if you increased it to 1 million, you would only increase the sample size up to 384. And if you went up to 10 million, that number would only increase marginally thereafter. So it's a very efficient way of extracting information. But it's all in the design. And I think then there is a question that comes out of boundary fairs as to whether one needs to do the survey at the CPO stage, and I think they say no. But I do think that it would be of assistance to the court whether you could specify the broad parameters of the survey that you're going to do. How will you segment the customers or claimants? How will you do the survey? What type of questions will you ask? And what are we going to get from this? And how will that actually input into the damages assessment? I mean, I'm seeing this through the damages assessment lens. Then we come on to natural experiments. Again, I think natural experiments are useful where they exist, and I'll say some pros and cons about them. I mean, essentially a natural experiment is observing an outcome in the market that has a particular conduct versus a marketplace that's doing exactly the same but without the conduct, and then looking at the difference between the two of them. And that was used in the Microsoft claim on the Microsoft media and the tying with its operating system. And effectively what the EC said in Europe was, the argument has been, if we enforce licensing, then that's going to stifle innovation. However, in the US, they had already accepted the licensing and made commitments that it wouldn't stifle investment. So that's kind of an interesting kind of experiment. The problem, though, is actually being able to control for all variables, right? This happens okay in a lab where you can control everything but the factor that you are trying to test. But in complex markets, many things might be happening simultaneously, and isolating those factors becomes more complex. So I did a case that was between two airlines. One had abused its market position to direct passengers in the travel agency sector, and when you got to the end of the infringement period, nothing happened. And so the other side said, well, that's a natural experiment. You've got a period with the conduct and you've got a period without the conduct, so surely that tells us something about the harm. Actually, there was no harm, they said. But I think that overlooks two facts. One, at that point in time, many other things were happening. So low-cost carriers were coming into the market. There was a movement from travel agents to online sales. But it also overlooked the fact of things like customer stickiness, that having moved to an airline and taking its frequent flyer program, I was never going to actually change back because the purpose of the frequent flyer program is to create stickiness at the end of the day. So I think one can use a combination of these. I'm always for a preponderance of evidence approach. I always think that their case specifics of what might apply in one case doesn't necessarily apply in another. But I think that it's an important tool, especially if you don't get disclosure. And these cases are tremendously difficult without disclosure. So anything that helps to inform, to get you through the CPO stage, and then you can get into disclosure, I think is, should be warranted and merited. So.
Thank you, Greg. Just a quick comment. I think I certainly got the impression that the cat thought that the extra £10 would more likely be spent with most people just going to the pub rather than paying down savings. Yep. Okay, let's hear now from Leonard Böhmer.
Well, the interesting news is that the pub closes at 8 today here in the Netherlands, so we're right on time. Just a few observations from a lawyer. The first one, I've got two observations. When you deal with with basically pan-European stuff that we do at CMS is, one, do realize that I don't speak English, and none of us at the continent do. We try to formulate our thoughts that we make in our own languages into what we believe is English, but we don't speak English. And that's a very important issue if you consider that we drive on the wrong side of the road. And it's not only that, because that's a legal issue. And that happens with evidence, with types of causation. We don't have the same system. And even the word "we" is inappropriate when you talk about Europe, because we've got, each jurisdiction has its own style, its own history, and it certainly differs from any Anglo-Saxon type. So that's the one observation. The second observation is we're lawyers. And I don't know how it works with you, but those were the people who were lagging behind on maths, anything that has to deal with numbers and figures. So we're good at, getting to the next 1,000 or 10,000, especially if we're billing, but not when it comes to assessment of quantum. Basically, I didn't understand half of what Greg's just understand, but I can nod and I can with the best of you. But it is very important to understand that most lawyers don't have a feeling for figures, and not just the instructing lawyers, but it happens to the courts and the judges as well. Of course, there are exceptions. There are people who are very good at it. There's also a group that has a great learning curve, but you will have to start from the very basic fact that we just don't really know, and this is only the good news. The other things is that lawyers, therefore, in litigation, in mass litigation, deal with all sorts of legal stuff like, is there a breach, and what about causation, and they focus on the very important legal aspects, and for some reason or another, quantum is always pushed to the back of the line. As well, we at CMS try to reverse at least the thinking and the of our clients, and it's a very big distinction if we work for insurers who are used to quantum and quantum thinking, or just ordinary customers, clients, who are basically not, especially because we're instructed usually by a team of legal people within the companies, if we work for the companies, and they haven't got a clue about quantum either. So what we try to do is, well, why don't we set aside all the legal issues that are there, and undoubtedly there, and will take 2 to 5 to 8 years to resolve, and look at the quantum as if the claimant is right. Because what you then see is that sometimes the mere amount that's hovering in the air, for instance, in the Lloyd case, whereby they said 4 million users times 750 pounds sterling is an enormous amount, and it paralyzes people in thinking. And if you turn it around and say, okay, well, let's assume that there is some sort of claim. What are we going to do with quantum? And as the UK Supreme Court said, and I think that's a, well, almost universal rule, compensation is about restoration of the situation where people were, if it wasn't for the wrongful acts, and you have to try to assess that matter. And if you start with that, as has been done in several of the diesel settlements, let's assume that there is an infringement. Let's try to minimize the causation discussion, and let's see what really is the harm done in terms of compensation. And I would add, and it's a word that I hardly ever hear at these conferences, it's also about justice. And this justice, this intangible but very important issue of justice creates a gut feeling of courts and judges, and you have to factor that in, and that's exactly what Greg Harman said. So the courts, generally speaking, especially in Holland, are very open to alternative elements, preponderant evidence of harm done. And you can go by it by all means, but that's in Holland, not necessarily in Germany, not necessarily in Spain, in France. It's different across the jurisdictions, and that makes it very, very hard. So you not only have to pick your battles, but you have to also pick the battle side, and that's the good thing about forum shopping, because the European Court, and then I'll stop. The European Court has made it quite easy with their decisions on how to locate the location where the harm is incurred, or where the wrongful act has incurred. Only pure financial losses is not good enough, but you have to have something else, and then you're in it, which is especially important in cyber and cross-border and infringements. But the other side of the question is, or the coin is, that the European Court then goes on and say, well, but you probably have then to apply the local law, which complicates matters, because we see cases whereby you have to apply 2 to 6 to 8 sets of law dealing with causation and losses as well. So my point is, there's a lot to do. There will be a lot. The circumstances of going into Europe will increase, especially with the collective redressing consumer directive. But you have to make sure that you're, as an expert, try to get in there as quick as possible to reverse the almost autistic approach by lawyers to deal with the legal issues first and the quantum last. That was my first take.
Thank you very much, Leonard. Just one observation, your comment about understanding half of the quantum issues reminds me of the old adage in advertising, which is that 50% of advertising is effective. The problem is you never know which 50%. So I don't know whether that applies to you as well. Okay, thanks very much. We're now going to pass on to Greg Leonard.
Thanks for that, Liam. So I just want to get one thing on the record. If there is a rail litigation following my disaster this morning, I was going to invest my proceeds in a combination of crypto and non-fungible tokens, particularly the ones that tend to go up significantly in value in the next year. So let's just get that on the record here. Seriously, interest rates are really complicated, and I don't want to delve in too much, but just pick up on and just mention that interest rates also compensate for risk, and it's a really challenging thing to think of from a financial perspective, and could be a really interesting issue in these matters. I want to talk about these large, high-stakes group litigations. And they are certainly, as we've seen, becoming increasingly globalized. We've seen high-profile examples of litigations filed first in the US and then elsewhere, such as here in the UK. The quantum in these class actions can face a number of challenges. I want to talk about 3 of those. First, these are really large and complex cases. They're global cases, so of course they're going to be complex. And just the size and the complexity can make quantum really complex. And the models are complex, accounting for the markets are complex. The simple build a model, put a dummy variable in, and calculate damages or quantum off of that dummy variable often don't work in these large complex cases. Second, and the risk of stating the obvious, there's significant coordination issues across jurisdictions. Is the impact of the alleged misconduct the same in each of the multiple jurisdictions? Market conditions can be significantly and materially different in different jurisdictions, and they can lead to meaningfully different outcomes in different jurisdictions. So the modeling, the economics of those markets can be different, massively different, and thus the quantum methodologies need to account and be different for the different jurisdictions. And third, and finally, and for me the most interesting in financial services, the trading markets, the financial markets are global. I can trade Brent crude oil, I can trade gilts, I can trade European government bond futures, I can trade FX from virtually anywhere in the world. And my counterparties don't necessarily know where I'm sitting. I don't necessarily know where my counterparties are sitting. I don't know where the bank clients may be sitting. Which jurisdiction do I belong to? Which claim do I belong to? You could imagine that the courts could actually set out a nice theoretical standard to divide up where my claim resides. Does it reside in the US? Does it reside in Brazil? Does it reside in the UK? But even if they can hand out and dispense guidance to determine which claim I belong to, the financial databases are not necessarily able to keep up. They don't necessarily know where I am, as I said. They don't necessarily know where that trader was. So how do we determine what jurisdiction I belong to? Does it depend if I'm trading Brent crude oil on where the Brent crude oil is physically located? Or in financial products like FX or government bond futures, does it depend where the exchange was? What comes into play? Those can be a real challenge. And I think I'll leave it there for now.
Okay, Greg, thank you very much. I'm going to open it up to questions from the floor, unless any of the panelists wanted to comment on what's been said so far.
I'm happy to have a call afterwards just to explain the other half.
As long as you know which half you're explaining,
we'll have
I think you're ahead of all of us. Okay. Do we have any questions from the floor or online? Okay. Let me kick off with a few just to take the discussion forward. I wonder if we could just come back to this issue of aggregate award, because it sort of sounds like it's sort of cutting a lot of corners, let's put it that way, and it's making life a lot easier for the claimants. But I wonder whether that is actually the case. I mean, when you look at Merrick's and you look at as I say, the ambition of compensating, a huge population for expenditure and overcharge that they might have experienced that was sort of passed on, whether they used the credit card or not, in all sorts of different sort of retail outlets. There's this idea that you can sort of come up with an average overcharge, but even there, behind that, there was a recognition that you'd need to sort of build up that average by looking at the individual rates of pass on in different sectors and potentially in different business models. So I just wonder, just a sort of general question, how much does the sort of, how much will turn on the aggregate award approach in terms of the methodology and the quantum challenges that the experts are going to face? Greg, do you mind if I start with you on that point?
Well, I think it is a challenge. The issue of pass on is a challenge because obviously there are many retailer claims on interchange where pass on will be a particular issue of focus, and until you understand necessarily what got passed on to consumers, if any, or if all of it, or what got passed on through other means, such as to suppliers, I'm not sure how one comes up with an aggregate case at the consumer level without potentially leading to double damages or overlaps in the amounts that get paid out. So I think that is difficult. And there also seems to be just a slight disconnect to me from an economic perspective, is that if the overcharge can be an aggregate claim, then that kind of sits at odds a little bit with the compound interest aspect of it in some ways. Unless the only issue that was on the court's mind was whether the money actually gets spent. But if the money does get spent, then simple interest should also not apply because the consumers didn't suffer the loss from that perspective. So, and I don't think it's just interchange. Obviously, you get this layering effect also in trucks, for example, where you have different parties in the chain. You have the logistics providers, and then you have people downstream of that, and whoever knows if there's going to be a consumer claim at the end of that as well. And again, there's very complex questions of pass on, and these issues are being heard potentially by different judges in different jurisdictions where there may be issues of consistency and continuity between them. And obviously, when those differences in judgments come up, that may well drive a wedge in proceedings in other places. So it is quite complex, obviously. I don't know what the solution is. Mostly legal.
Yes. No, thank you. Leonard, perhaps we could get, I have to admit that as a quantum expert, my understanding of the legal issues falls way below the half level, if that gives you any comfort. But perhaps you could sort of fill us in on how this sort of aggregate award framework is panning out, if at all, on the continent, and what your perspectives are on that.
Okay, so I have to rely on a bit of the expertise of my fellow lawyers at CMS, because I mainly practice in Holland. What you see is that, again, it's a patchwork of notions and approaches, not only because of the various legal issues and the lack of sophistication in terms of thinking of aggregate awards, but also on the lack of sophistication with the various courts. So it has become very important in which court you actually litigate in terms of getting expert judges. For instance, in Holland, the Amsterdam court is very experienced. There are several other courts are very experienced, but other courts don't have the experience. In Holland, we have the method that one court can basically call in an expert judge of another court to help and assist. So, and that's being done. So the answer, this is a long that I really don't know which way we're going. For instance, in Holland, courts are allowed to come up with their own assessment of the loss, and therefore are interested in looking into our aggregate awards. But other courts will simply go back and say, no, I want to really address the loss suffered by the claimant or the individual claimant itself, and you have to come up with a story per claimant, which makes life very, very difficult. On the issue of passing on defense, at least in Holland, there's roughly the rule that it is once the infringement is accepted and there is some sort of loss, the passing on defense will have to be proved by the defendants, which then creates a reverse lack of data issue. And that's also an issue that underlies the issue of aggregate awards, is where do you get your information, and how, and who has the burden of proof, and what kind of evidence is accepted. And as far as I'm concerned, I will be able to answer that question in about 5 or 10 years' time, because so far it's a very gray area, which also means that anything creative will do, as long as it's convincing, and I believe it should be also directed to the gut feeling of justice by the courts, not just the technical issues, but you have to take in the emotional or the non-rational issues as well.
Thanks, Leonard. Greg, go ahead. Give us a transatlantic.
I'll just add really quickly that in financial markets and trading markets, the notion of aggregate awards have an additional layer of complexity. The complexity of the positions, the fact that claimants both buy and sell the product, both pay and receive the spreads, for example, in many instances means that averages, while there are always challenges around them, can be even much more challenging and really may not reflect sort of individual damages and the sum of individual damages. That's particularly true when you think about hedging and positions that reside across multiple jurisdictions. So it's even, doubly true in the big global financial markets class actions.
Yes, no, absolutely. The disguising a lot of class conflict effectively. And to your point, Leonard Böhmer, about the creativity of answering some of these questions, I mean, it does seem to me that the sort of survey approach does seem to go sort of hand in hand with filling in some of the gaps or addressing some of the data challenges around the aggregate award. But as Greg Leonard says, what might be lost in terms of the accuracy and what might be disguised. I mean, we often refer to the idea of the tyranny of the average. The sort of you've got your head in the freezer and your feet in the oven, but your average body temperature is okay, kind of thing. Okay, has that bought some time for people to muster some questions? Thank you.
Yeah, so Willem Weiser says, the way courts assess damages in the EU varies. Do you agree that the guidelines prepared by the European Commission on the passing on defence will lead to some kind of harmonisation?
Yes, good question. I mean, I'll have a brief comment on that, which is that those guidelines, I think, were based on a rather thick report by one of our esteemed competitors that suggested that the court only needed to go through 39 steps to assess Passon, which always reminds me of the film The 39 Steps, which involved a rather harried person being chased across the Scottish countryside by some gangsters. And I sort of wondered whether the judge might himself or herself feel that they were the person being sort of being pursued in this case. I mean, from my perspective, I think Passon essentially is about 3 fundamental questions, and that is, were you as a competitor being overcharged more or less than your competitors? How effectively were you competing with those competitors, and how significant was this overcharge as a proportion of your cost base. So a little bit of boiling down from 39 to 3 might assist the courts. I don't know whether that's really reflected in those guidelines, but that was my 2 pence worth on the Passon debate. But Greg, is this going to help? Is this going to smooth the consistency across different jurisdictions?
No, I don't think so. I mean, look, it's a list. There are some good points that are made. I hate being constrained in having to do things in a certain order and in a certain way, in part because every case is different, right? And in part, Passon will be determined in part by evidence from the factual record, and access to data therefore has a massive impact in terms of which of the steps you think that you can go through. I mean, I think most economists will approach it from a similar position. Maybe only 5 of the steps or 6 of the steps will be applied. But I think at the end of the day, as Liam says, there's some theory about what happens, and then that theory can be tested by evidence from the factual record at the end of the day. And there are some other important things, for example, such as how are prices actually set within the business. And so if you were a cost-plus type of business, you might predict the greater elements of Passon. But if you were a luxury branded good who sells their merchandise on consumer willingness to pay, then maybe things don't get passed on as and when costs, increase. So I think each case, one by one, you might have regard to that report, but you apply it to the facts of the case.
Leonard Böhmer, do you have any views on that question?
No, I fully agree. And just another complexity added. It also depends on how the case is litigated, which points the claimants and the defendants have made and which points the courts have accepted. So, it's a guideline, nothing else.
Greg, Leonard, anything to add? I know there are idiosyncrasies of Passon in complex financial services markets, something getting debated at the moment.
Yeah, I don't think we'll be able to go into the details of it. It's really complex, and I'll leave it at that in financial markets.
Okay. Do we have any other questions? Any more from the floor, from the online? No? All good? Okay. Well, I think we'll draw it to a close there and just leave you to thank the panel with me. Thank you.